Every 27 seconds, someone gets divorced in America. Apart from custody issues, divorce is primarily about money, and nobody knows more about money than accountants. Hi, I'm Sam Rosen. I'm a forensic accountant. It's my job to determine how much money is really being earned and how much the business is really worth. Husbands and wives go to great lengths to hide money. On tonight's episode of White Collar Crime Report, we're extremely fortunate to have two of New Jersey's most respected lawyers. Frank Donahue is a partner at the prominent law firm of Skoloff & Wolf of Livingston, New Jersey. Frank is one of New Jersey's preeminent divorce lawyers. He's well known and respected by matrimonial judges throughout the state. He was the Baby M attorney and was awarded the Family Law Attorney Achievement Award. Dan Coburn, whose law practice is in Morristown, New Jersey. He's a former New Jersey Superior Court judge. He was the head of the Public Defender's Office and a law professor. He's the author of numerous books, articles, and editorials, and was a TV commentator for Court TV. Dan, you developed the Enforcement Court Program. What is that?
It's a program set up so that victims in particular who are owed money, whether it be money was stolen or an injury, something along those lines, is able to go to a much more relaxed, user-friendly system, request that the money be paid back. The person who owes it has to come in. It's done as an adjunct to the court system. There's a referee. I was the original person after I left the bench 3 years ago today, as a matter of fact, and I served as a referee. I would make recommendations. If the person's agreed with them, we could issue a wage garnishment right on the spot.
This is for owing money for all
anything related to crime, anything at all.
And these are victims of crime? These are civil lawsuits for compensation?
No, they went right through the court system because restitution, which is repaying a victim, whether it be a company or an individual.
Let's assume somebody embezzles money from a company, and as a result of a criminal crime, that individual is first indicted and then convicted.
In order to pay back $10,000, they're not getting their money back. They could come to the enforcement court very informally. The person who owes it is brought in. You try to work out an agreement. You try to arbitrate it without going before a judge. If there's an agreement, a recommendation is made, a judge signs it. It's the same as if you appeared before a judge, except that we've done about 10,000 of these, and we've only had 8 ever appear before a judge.
So it's a speedy process to get your money back.
It's speedy and it's effective.
What gave you this idea, Dan?
When I was a judge, I used to see how ridiculous it was that when it came to money issues, that the court system was spending more time on procedure than it was on performance. And the idea was to try and get people their money. There's other aspects to it, but mostly it's victim-oriented.
Could you adapt this to a family court context?
Right now, there's a pilot project being developed, and what it's going to be is in the situations where one parent says, I'm not paying child support because the other one's not allowing visitation.
Right, that happens all the time.
We're going to try and figure out if there's some way that we can equal this out instead of wasting judges' times. And if we can't even do it there, from a sanctioning point of view, under the legislation, the enforcement court legislation, a court can order you, instead of going to jail, which is really a drastic measure, to do community service under the supervision of probation. If you don't do that, you don't comply, then you go to jail. But it's a middle step.
Frank, you know Dan a long time. Is it?
Too long, much too long.
Right.
But this would be an excellent program in the matrimonial courts because any Friday that you go to a matrimonial division, you will find motion upon motion where arrears have accumulated over the years.
Both in alimony, child support, people haven't paid.
Of course. And a system like this would be very helpful.
What got you into matrimonial law, Frank?
Well, when I was in law school, I didn't really like my matrimonial course, but at the time I graduated, I looked for a clerkship. Back then, it was very common to clerk for a judge, and there happened to be a matrimonial judge who was looking for a clerk.
Here in New Jersey?
Right here in Newark. Morris Hartman, who had been one of the preeminent matrimonial lawyers in his career, went on the bench, and I wound up as his clerk, and that started me in the direction that has taken me 25 years down the road to your studio tonight.
And have you worked on cases with Dan?
Yes, in fact, we have a major case, maybe the biggest case that I've handled in my career. I know Dan is used to those multi-million-dollar cases, but this is a major case involving a lot of assets worldwide, not just here in New Jersey, millions of dollars in income. We have accountants, we have major accounting firms, we have business appraisers, we have real estate appraisers, and we work as co-counsel on this case.
You know, you hear the phrase in sports, a career season.
Right.
This is a career case in the sense that Frank and I, at the end of the case, will be experts on something that we'll never see again. But I know with your practice, you know, you're into all this. Well, if you took about 10 of your collective most difficult cases,
This
and you
would
put
be
it
one
in
of
here.
those?
Yeah, and we're not talking about because somebody's doing something wrong or right or whatever, but complex cases require a lot of onion peeling. And that's basically what
Well,
we
I
have to
said
do.
in the opening, divorce is primarily about money, or mostly about money. Is this case primarily about money? Are you spending all of this time and complexity developing a marital history in terms of finances?
This is what I do 95% of my time. Most of the cases that I handle involve reconstructing the financial history of the marriage, finding out where all the assets are, what they're worth, what the income is, what the true income is, and then presenting to a judge the position of my client. If I represent the husband, naturally I'm conservative, and if I represent the wife, I try to predict the future as being very rosy.
Well, attorneys are supposed to be advocates, unlike accountants who are supposed to be
And you get
objectives
you get
and
the
independent.
direction from the client, because if the client says, look, our lifestyle certainly exceeded, you know, a $500 a week income, you have an obligation to pursue it unless your client, you know, is bizarre. And that's how most of these cases get
Do
started.
you find that most moneyed spouses, the spouse that has the assets, that has the business, that earns the greater amount of the earnings of the two of them, hide assets during their marriage or during the divorce? What's your experience?
If a spouse who has the assets and has the income expects a divorce in the future, I can almost guarantee you that there are going to be hidden assets, that income is going to disappear. It's simply a fact of life. If you believe you're going to be divorced, you take precautions.
What
And
kind
we
of
see it.
precautions could people
Well,
take?
right now, you do retirement planning. Well, and you do educational planning.
Right.
Well, there's now divorce planning. And that is that, you know, I'm not saying that people are stealing stuff, but certainly you have to start taking into account what happens when there's a divorce. And some people take it into account, don't like where that takes them fairly, and decide that they're going to reconfigure.
I know as part of my accounting practice, occasionally we've planned friendly divorces between spouses, one who's in trouble either with creditors or with the law. How do people go about doing that?
Well, it's not uncommon to have families in financial trouble. And most spouses would prefer to see the other spouse and the children get the assets and get the income rather than give it to creditors. So very often where they see a bleak financial future, what they do is they plan to make a matrimonial settlement which will benefit their wife and their children rather than give it over to either the government or
And so they
creditors.
plan a divorce.
They actually plan a divorce, yes.
And does that shield the assets from creditors? Or could it?
In some instances, it does. If a creditor, for example, if the spouse files for bankruptcy within a certain period of time, those transactions, those transfers of assets to the other spouse could be disallowed.
Dan, you were involved in the Quinlan case. What was that about? That was a very well-known case.
Well,
years ago.
if you want to take a look at it, it's interesting. I had this discussion last week. We were talking about O.J. O.J. is the most famous case of all time.
Right.
But if you want to talk about the case that had the greatest impact
certainly
on...
did get a lot of media time. the
Well,
OJ
it certainly
case.
was publicized,
Yeah.
but if you want to take a look at the case that had the greatest impact on people, the Quinlan case did in one sense. We're all going to die.
Right.
That's a given. And the question is when and under what circumstances. And that's what Quinlan was about. How do you die,
Not
and
to
what society?
interrupt, but I think the Baby M case was
Right.
far more significant than the Quinlan case.
Frank,
That's
you were
only because he handled that case.
Well,
and I
Baby
handled
M
the other.
couldn't have even been thought of 25 years ago.
You're
could
right.
it?
It was inconceivable back in my youth that we would have in vitro fertilization, people carrying other people's eggs and having all kinds of scientific methods of birthing children.
That's what's going to change litigation, because 5 years ago, who knew DNA?
Right.
And who knows what the next advance is going to be 2 more years from now.
Well, the Quinlan case involved the proposition of when to shut off these machines.
Yeah, you're
As I
right to-
recall, in the Quinlan case, they decided to shut off the machines, but she lived for some years afterwards.
10.
Right? 10 years.
10 years.
So the case was about shutting off machines, letting her die, and she didn't.
Well, it was
She fooled everybody.
it was allowing nature to take its course, or if you're very religious, allowing God to take its course. But regardless, it set a pace. But you notice how tactfully that was handled versus you see something like O.J., which
Right.
was the Mardi Gras.
Well, the Quinlan case was highly publicized.
But it may have been publicized, but the issue was repeated and repeated, and it certainly awakened a lot of people.
How did you get involved in the Quinlan case?
I happened to be an attorney up in Morris County where the case started, and I was also head of the public defender's office and also teaching at Rutgers Law School. And the theory was somebody was going to have to do it for nothing, which didn't bother me too much.
Was this before or after you were a judge?
It was before I was a judge, and I had the facilities to use at Rutgers Law School. It wasn't a public defender case, but I had at least the government experience to be able to, get people to help. And probably at that time, the only two government attorneys were the prosecutor and the public defender. And so I was asked. I was very thrilled to be asked.
And you were representing the proposition that the machines should be shut off or shouldn't be?
No, I was asked, I was given a charge. The charge was protect her rights under the law as it exists now. Under the law as it existed at the time, they could not discontinue life support systems. The case then allowed the discontinuance of life support systems, which I happen to have agreed with right from the start. But if I didn't
that
want,
wasn't your position
That
in
wasn't
the
my
case.
position because I was told, look, this is the law. You must try and uphold the law.
Frank, how'd you get involved in Baby M case?
Well, the Baby M case came into my office to my partner, Gary Skoloff. And Gary guaranteed the Stearns, whom we represented, that this case would take only a few months and it would be over. 6 months later, Gary came to me and asked me to help him try the case. And it went on from there. It was nationally publicized. In fact, throughout the world, people were familiar with the Baby M case.
Gary also predicted the O.J. case would take a week.
That's right.
We're just going to take a short break, and we'll be back to talk about Baby M and other matrimonial cases.
The music was loud and we was laughing and joking around. There's 3 shots fired. He was killed. It really hurt. Why did this have to happen?
Unfortunately, Alicia's story is all too common. Children with their childhood taken from them. Fear of violence is robbing our children of their future. We must take away that fear and give them hope. We must give Alicia and all our children back their childhood. Working together, we can.
Do something now. Call 1-800-WE-PREVENT.
It may not look like it, but you're watching the future of the Earth pass by. Because many of these products are made from materials you've been recycling. But to keep recycling working, you need to buy products that say, made from recycled materials. For all those next in line, it would mean the world to them.
This is Sam Rosenfarb, and we're talking with Dan Coburn and Frank Donahue on issues relating to matrimonial law. Frank, right before the break, we started talking a little bit about Baby M and your involvement and Dan's involvement in the Anna Quinlan case. And you told us about a matrimonial case that you're involved in.
Yeah, well, apropos of those two cases, they were cases that broke new ground in New Jersey, and we see that happening more and more frequently. And apropos of the Quinlan case, I just had the first case in New Jersey where an incompetent, the wife who was in her mid-80s, was allowed to sue her husband, also in his mid-80s, for a divorce. Prior to that, New Jersey, incompetents could not file divorce actions.
What did they have to do? They just had to stay married.
They had to stay married unless the competent spouse filed a divorce action. In this case, the competent spouse had left his wife, was living with another woman, and if the spouse, the incompetent, had died...
She didn't know.
She didn't know,
Right.
but she would have lost her rights to the property. And as a result of that, the judge felt that she was entitled to receive her share of the property and pass it on to her children. So for the first time in New Jersey...
He, in effect, divorced his children as well. Then.
Exactly.
So he divorced his wife, divorced his children, lived with some new person, and tried to cut everybody out of his assets.
That's right. And New Jersey recognized the fact that this woman was entitled to the property, gave her a divorce, and she passed it on to her children.
Is that unique to New Jersey, or are other states as aware?
We looked throughout the country to see if there were similar cases. And in a couple states, they've had cases where incompetents have been able to sue. But it's really pretty novel. And Alzheimer's, you know, with people aging now, having longer lifespans, I think we're going to see more of this type of litigation, which is kind of unique.
That's what's happening since the 60s with all the technology. There are issues coming up that people just can't even believe.
Right.
And they say, well, how come this case never occurred before? The reason is because people didn't live as long, and they weren't able to be, maintained as long, and they didn't have money to the extent that they could get involved in this because people didn't get divorced.
Well, people seem to be spending more and more money on divorce. What should people do when they consider divorce in terms of their assets?
Be reasonable.
Be reasonable with each other?
Well, a lot of times what happens is you have a 25-year marriage, and I mean, it's been a fairly solid marriage. Something goes wrong the last year, and all of a sudden you would think that you had two psychopaths dealing with each other, and they forget that things don't work out. We're a plastic society, but that doesn't mean that it becomes a battle. The War of the Roses, that movie, every matrimonial lawyer I know can recognize parts of it as being one of their clients.
Is mediation an alternative?
That's
a
helpful.
reasonable alternative?
Mediation sometimes helps, but if you have two reasonable lawyers, no matter how unreasonable the litigants are, you should be able to settle the case.
That's true.
90% of matrimonial cases are settled.
But they're settled after lots of tribulation and lots of cash is expended on fees, including accounting fees.
The reason for that is
a great deal of our firm's income is generated through divorce work, through discovery.
But Sam, what is the reason for that? The reason is that under our divorce laws now, spouses are entitled to a fair share of the assets.
Right.
Very often the assets are difficult to identify, to value. Much of the litigation now is financial litigation.
And what's the
you do
alternative?
get custody cases that are difficult cases,
right.
But most of what we do is try to value assets, and you know as an accountant how difficult that can be, and you can have differing opinions.
Part of it is also trust, that as the marriage is breaking down, so is the trust, and you're an attorney and your client is giving you some directions, you know, don't trust them on this, don't trust them on that. We have different types of assets today than we had in the 50s with all the pension plans and all of this. And so you get into it, and you really have to pursue it, because if you don't, you're committing malpractice.
Right.
And if you don't, that case is going to be in court for the next 30 years, arguing over...
Does it help to have one accountant for both sides, one business appraiser, one evaluator of assets? Does that help?
If the parties can agree, and what Dan said is there's a lack of trust. In a divorce case, the husband does not trust the wife and vice versa. So it's difficult to get independent accountants appointed by both parties.
But isn't that a function of the attorneys and the strength that the attorneys have in advising their clients?
Very often, an attorney can control his client, and that's why I believe 90% of the cases are settled. But very often, attorneys don't get along, and very often, attorneys cannot control clients.
I saw that as a judge, that you could see that the problem was more the attorneys than it was the clients. And any attorney can handle a matrimonial case. Depends on what level they're at. And so what happens is, if there's a group of attorneys that have to deal with each other, there's some built-in controls. But when you have some lawyer from Philadelphia up here, or somebody from Boston down here, because if people are getting crazy about it, there's no trust. I mean, it's a war.
Our attorney, do you find, and you're an attorney, and both of you are attorneys, but when you were a judge, did you suspect that some attorneys were merely churning the fee, churning time, creating time to generate fees?
The better way to say is they weren't controlling their clients. That's a better way to say. If you don't control your clients, fees are going to build up. But the difficulty is, I have a client, and my client is unreasonable. Well, Frank, representing the other person, has to defend against the unreasonable charges, and that's where everything
That's what
goes.
creates additional fees.
That it really does, because you can't just roll over and say, this is nonsense, I'm not going to defend against it, because they're going to win.
When a spouse accumulates assets that have been generated through unlawful means, let's assume he runs a business and it's a cash business. He's reporting much less income than he's actually earning. And this cash accumulation gives rise to save cash in boxes or accumulation of real assets, investments, real estate. Tell us about this case in New Jersey called Sheridan. What Sheridan has said about people who have accumulated assets through unlawful means.
The Sheridan case sent the shockwave through New Jersey matrimonial courts. What happened in Sheridan was that...
Yeah, and our viewers should know about Sheridan because there are a great deal of them.
I think they should, because it's a very dangerous case for people who have unreported income or assets that were accumulated through unreported income. What happened in Sheridan was that it came to the judge's attention that there was unreported income. In New Jersey, the judges have an obligation to report any crimes to the appropriate authorities. Not reporting income is a crime. In that case, it was sent to the information was sent to the IRS. But the judge went a step further. For the first time in any matrimonial case in New Jersey, what he did was he put a trust, he imposed a trust on all of the assets.
So he confiscated all the assets.
Confiscated the assets till the IRS could work out exactly what the problems were in terms of the taxes, penalties.
So he in effect said a pox on both of your houses.
That's
the
right.
husband and the wife.
So
I'm not distributing anything.
Both parties suffered as a result of that.
Yeah.
So that now when parties come in and they accuse their spouse of having unreported income or assets that were accumulated through illegal means, you have to advise them that they are at risk, as well as their spouse, of having all their assets taken by the court and held in trust for the Internal Revenue Service.
So what do you do with a couple who comes in and...
Uncle Sam, by the way, who never loses, is going to do something else. Because if you think it's just splitting up the money, then come the penalties and whatever else, and always that ugly possibility of a criminal prosecution. And then you sort of look and say, well, you people figured out how to settle this case, because now no one's going to have anything.
So they almost forced to settle a case.
They're forced to be reasonable.
To be reasonable. Are people ever reasonable?
Oh, I
Very
think so.
often,
Yeah, they are.
there are people who come in and they want to do the right thing, and it makes it a pleasure to represent them.
What was your most interesting divorce case?
I would guess the most interesting case that I had was a case that involved unreported income, but the unreported income took the shape of gold nuggets. The business that the husband was involved in had to do with taking gunk that contained precious metals, and he would smelt it down, and it would be assayed, and he would give the business whatever the business thought was in the gunk, and he would keep the rest. I tried the case with a mayonnaise jar this big with gold nuggets in it sitting on the counsel table.
And what was he doing? He was skimming off some of this gold for himself?
The companies who would give him the gunk would assay it. They would figure that there was 2 ounces of gold.
How did you get your fee out of that can of, that jar of mayonnaise?
I still have the jar.
You still have, I've noticed these
I don't have the
tie tacks.
gold, but I
He
still
has
have the
these
jar.
large nugget tie tacks.
But we tried to settle that case. Before we tried the case, we told him, and this was many years ago before Sheridan, and we said to this individual, look, we know you've been taking metal. We have it right here. Let's settle the case. He absolutely refused. Talk about unreasonable people. So I had that jar of gold. The judge referred it to the IRS. We did very well. The husband did very badly.
That's too bad.
To this day is paying the IRS.
My most interesting case was a guy came in, wanted to be divorced, typical garden apartment case, who gets the records and who gets the Firebird and the Camaro. So I said, well, this is easy. And he said, there's just one problem. And I said, what? He said, we're not married. And what had happened was that he had said that his girlfriend, because that's what she was, the two of them had gotten married and they were living together because the parents had come down to visit them at school, and they said, well, we're married. And now they had broken up.
I mean, they were lying to their parents because they didn't want to admit that they were living together.
Right. This is in the 70s, and then the next
You hear
thing
that,
I
kids?
know, next thing I know that they want. So I said, well, why don't you just tell your parents you're divorced? And they said, my father wants to make sure that things work out well, and he's going to be in court. And I said, this is a real interesting case, and I hope you find some judge that's going to go along with it. But
It's a scam.
well, I could understand why they wanted to do it.
Now he wanted to get divorced. But you were involved in a very interesting case. Didn't you fly to Belfast to get involved in some murder trial?
Yeah, there was a hearing on a murder. It was a clear murder. It was a machine gunning of an innocent cab driver by terrorists in the Catholic Protestant section.
And how did
of
you get
Belfast.
involved in that case?
I really, I could tell you how, but it'd take too long. But the real question is, why did I get
Why
involved?
did you get involved?
It seemed interesting at the time. It still is interesting, having done it, and I would go back again. But it was just a fascinating experience to see them watching the O.J. case and see everybody in Belfast looking like every kid in Morristown and Elizabeth or any other place. But it was interesting.
Very interesting. What advice do you have for people who are contemplating divorce? What should they be doing?
Well, I think
Just before they've seen an attorney.
Before they've seen an attorney, I think what they should gather is all the financial information they have, because as we've made the point before, finances is what divorce is all about. I have people come in, they have no idea what the income is, what the assets are. That makes a difficult beginning. So the first thing they should do is get their finances in order so that they can tell their attorney what's involved in the case.
Dan, any last parting words for people's greed and how to avoid it?
Yeah, they should go for counseling first, because I'll tell you what, there's no one that will ever tell you a divorce is fun and the experience is fun. And they really should think about it a long time before they get divorced. When they get to the point that they are getting divorced, then the issue is preparation. That's the whole key, before you get to the lawyer.
I think Dan is doing counseling too, right?
I'm in counseling.
This is Sam Rosenfarb for the White Collar Crime Report. Don't let the greed get you. If you have any questions about tonight's show, give me a call or write to me at 75 Livingston Avenue, Roseland, New Jersey, 07068. Thank you very much. Thanks, gentlemen. Most new jobs in America are created by small businesses. These businesses are usually owned by 2 or 3 equal partners. Oftentimes, these business families experience divorce among the business owners. A business divorce is sometimes more emotional and more messy than a matrimonial divorce. I know. A business divorce is about money, and nobody knows more about money than accountants. Hi, I'm Sam Rosenfarb. I'm a forensic accountant. It's my job to determine who's taking what from whom, how much money is really being earned, and how much is the business really worth. On tonight's episode of White Collar Crime Report, we have 2 partners from New Jersey's oldest and most prominent law firm, Stryker, Tams & Dill of Newark, New Jersey. Stephen Nee is one of the managing partners of the firm. He's also director of the Corporate and Business Law section of the New Jersey State Bar Association. Steve is listed as one of the best lawyers in America and who's who in American law. He's an author and a frequent speaker on corporate and commercial law topics. We also have Martin G. Gilbert, who's one of the senior litigation partners of Stryker, Tams & Dill. He specializes in commercial litigation and has been the attorney for major banks, insurance companies, and corporations in a broad spectrum of complex proceedings in courts throughout the United States. Steve, how did you become interested in corporate law?
Sam, I grew up in a business household. My father, as a young man, started a business, and we were always brought up in that atmosphere, so it was only natural that when I studied law, I was interested in the dynamics of business and how it worked in a legal context.
Was he a sole owner of his business?
Originally he was, and then in the early 60s, he went public through a merger.
Oh, so then he had many shareholders.
After that, he had many shareholders. But before that, he was a solely owned business.
Martin, in doing a lot of your litigation, is it for some small, closely held businesses?
You bet.
Yeah.
Most of the litigation that's taking place today in our chancery courts on a rundown, routine, day-to-day operation.
Explain chancery courts to our viewers.
In our system, we divide the routine law cases from cases where equitable remedies are sought. Equitable remedies, for your viewers, means something else other than money damages. Let's say you want money rescission back. Let's say you want stock sold or ordered. Let's say you want to be installed back in a company that you've been thrown out on. Anything other than just give me money damages, and you're likely to be in New Jersey's Chancery Court. It tends to be a businessman's court. You reach a businessman's judge. It's a sophisticated place.
And is it a lot of the litigation in Chancery Court related to small, closely held businesses?
Chancery Court's a wide field. It takes in everything from a foreclosure case to a property dispute. The judges tend to have a huge spectrum of experience in all kinds of matters. But if you're stuck in what we're talking about, a business dispute involving a small corporation that's going to split up, that's where you're going to be.
All right, Sam, one thing that unfortunately, while the Chancery Court does do business cases, one thing we don't have in New Jersey, which New York just implemented a few years ago and has expanded, and Delaware and some other states have, is a business court. And
a court solely devoted to business.
Court solely devoted to business.
Yeah, as an accountant, I'd like that, because then I'd have judges who understand businesses.
And the corporate business law section of the State Bar is now undertaking a study to determine whether or not we will make a recommendation to our Supreme Court to establish such a court.
And then that would be another court in addition to what we now have: family court, criminal court, Chancery Court?
It would be a part of the Superior Court, of which the Chancery Court is a part of, but would hear just business cases.
What kind of, Steve, you get involved primarily in the planning of forming a business, operating the business. Once a dispute occurs, I guess it goes to one of you. You don't necessarily get involved in that.
I don't get involved in the actual litigation of it, but I do get involved in some of the quarterbacking of it.
What is the kind of planning that people can do when they establish a business?
Well, you know, it's sort of like a marriage. When two or more people get together to form a business, it's like getting married. They're going to be with each other every day, and they do have fights, and they do get, unfortunately, into situations.
People spend more time together in business than they do at home with their wives, right?
That's right, and they unfortunately sometimes wind up in a divorce.
And I've also been told that in business, there are more decisions than you have to make at home with your wife. You know, major decisions.
Right, that's true. And so just as people today in a marriage, especially a second marriage, will get involved in a prenuptial agreement, it's good planning to have a similar type of agreement when people get into business. And that's normally accomplished by a shareholders agreement, which governs how they're going to vote as shareholders, normally to elect each other directors.
Is it required to have a shareholders agreement?
It is not required, but it's good planning because people have to remember that under our corporate law, a board of directors runs the corporation. And while shareholders get to elect the board, they don't run the corporation. And so if a person is in business with someone else and is not on the board, that person has virtually no power at all. So it's a good idea when two or more people get into business and they're all going to be equal participants to, in a shareholders agreement, agree to elect each other directors, and then as officers as directors to elect each other officers, and then to protect themselves that way.
Now, I've seen lots of businesses in my accounting career where there are two or sometimes three equal partners and two gang up on one. And the two of them decide to pay one less or to provide less perks to one, or to move his office, or to remove certain assistance from him. What happens in that kind of case, Martin?
Or worse yet, imagine coming into your office one day and finding out you don't have one.
Right, it's been eliminated, or the locks have been changed.
It happens. It happens every day.
What kind of remedy do people have?
The first thing to recognize is that you are a minority shareholder. If you're being
that has nothing to do with your race or nationality,
no,
right?
Not at all.
Right, okay.
You're a minority because the other guys own more stock than you. Understanding that's very important. No court's going to give you everything you want just because you are a minority shareholder. But you do have rights under our statute now, rights you didn't have before.
Is that unique to New Jersey?
No, not at all. Our statute's been modeled on a couple of other states. The current amendments go back as far as 1978. They've gotten a lot of play recently by our New Jersey Supreme Court because we've expanded what a minority shareholder can do beyond what they used to do.
Such as what? What is it that a minority shareholder has rights to do? What if I find one of my shareholders, I find my equal shareholder stealing? He's dipping his hand in the till.
Well,
so I throw him out.
Sam, if somebody does that, if somebody is stealing and you throw them out, you're justified. The statute covers situations where people are oppressed. And oppression under the statute doesn't mean what you think it might mean by the sounding of the word, but what it means is that the reasonable expectation of that shareholder, which the other shareholders know about, for instance, to be a director, to be an officer, are not fulfilled because somebody gets fired or somebody gets thrown off the board. One thing you can do as a planner is to try and protect against it by having employment contracts, having provisions whereby the entire board can only the entire board can terminate a contract. But even the best laid plans go awry and you wind up in court. And that's where Martin comes in and that's where the statute comes in.
And the statute lets you bring a variety of remedies. Oppression is only one of a bunch of alternatives that you've got now under the statute.
Oppression sounds subjective. You know, most minority shareholders who've been terminated must feel oppressed. That doesn't necessarily mean that they are oppressed.
Steve put his finger on it. Yeah. There's a magic phrase that the Supreme Court uses. It says, the reasonable expectations of you as a shareholder have been frustrated. Well, what does that mean?
Right. Who knows?
It doesn't mean that I'm a minority and I'm not getting what the majority gets. It means that when I went into this relationship, whatever it was, I expected and reasonably expected I'd get certain things. It can be almost anything, Sam. It can be a salaried agreement. It can be a corner office. It could be dividends. It could be your son, daughter, or brother-in-law employed in the business. It can mean any host of things that you expected to get, even though you were a minority shareholder. Now, you're frozen out. They took it away from you. That's a way to go into court and say, that was my deal. I lost it.
And the law could protect you?
With a big, big caveat.
Right, as long as the other side, as long as the other shareholders knew about your expectations and they were reasonable. That's the terminology used by the court.
So if I become a minority shareholder, a 20% shareholder, and my co-shareholder owns 80%, but I demand and he agrees to provide me a corner office, my son entering the business, my wife can be the bookkeeper, and I can have a full-time secretary and only work 3 months a year. If he agrees to that, then he can't take that away.
With a big caveat.
Yeah.
The Supreme Court came down with a big case about a year ago, Brenner versus Berkowitz, and the court said, wait a minute, it's not enough just to do bad stuff. It's got to be substantial. And they told you what they meant by that. It's either got to affect your rights as a shareholder personally, or it's got to affect your interest, your stock, the value of it in the company. The court gives the great example, and it's kind of anecdotal. If you've got a corner deli and the majority shareholder is throwing pounds of bologna out the back window, that might be serious. But if you're IBM, that bologna doesn't mean anything.
Right. What kind of cases do you get involved in, Steve?
Well, you know, in this area...
These don't have to be big businesses that have these plans.
These are normally small businesses or medium-sized businesses. And what you do is you get a situation where two people become partners. In effect, they form a business. Both people put up the money. One person is the president, another person is the vice president. They split up the other offices between them. One person may be a workaholic, the other person isn't, and he takes control, and he works very, very hard. And as time goes by, he feels he's working much harder than the other person. They're drawing equal salaries. He thinks it's not fair. He starts to moan, he starts to groan, he starts to take more money, and eventually they have a fight, and he throws the other guy out. Mm-hmm. Those are the types of problems. Or you have a situation...
And can he throw them out even though they're equal shareholders?
It all depends. If he's the president and the other person is an employee, the president has the right to fire employees. So unless you've done proper planning with an employment agreement that can't be terminated except by the entire board, of which you would be a member.
But if they don't have any employment agreements, then the president could fire anybody.
President can fire him, exactly.
And usually they don't.
Usually they don't have employment agreements.
Sure enough.
Sure,
when the company started, everybody's pals. Fred and Sam and Steve, we're all starting a business. We're all going to be doing great. Who could imagine that 10, 15 years later we'd hate each other's guts?
It's a lot like marriage sometimes.
Right. Happens all the time. The other situation, which is also a classic, is you have a father starts a business. You have one child in the business, another child not in the business. When the father passes away, he leaves the child in the business more in so far as a percentage of the company than the child who's not in the business. But the child who's not in the business always got a salary. The child in the business starts making the business more successful. a fight develops, and all of a sudden the child in the business cuts the salary of the child who's not in the business off.
Is there a lot of
Another fight.
litigation among family members in business? Is that?
The courts are legion with stories of family businesses that enriched Steve and I for the most part. Like a lot of other groups, they would do a heck of a lot better if they thought about what they were getting into before they started. The consequences are enormous. The power of the Chancery Court under our corporate statute and under the way the Supreme Court is telling us these days is tremendous. I'll give you, for instance, stock. You own 50%, I own 50%. You may bring the action wanting me to buy you out, but the learned guy in the black robe decides that it's better that I have to buy you out. You didn't plan on that.
No, I didn't. Well,
suddenly, there's a lot of money riding on it, and it's the wrong money.
We'll be back after a short break. We have with us two of New Jersey's preeminent corporate lawyers and litigators from the firm of Stryker, Tams, and Dill in Newark. This is Sam Rosenfarb for the White Collar Crime Report. Be right back.
Mm-hmm. 2 o'clock. Okay.
Your employees who serve in the National Guard and Reserve may seem different. They may work a little harder, be more confident, more willing to make the extra effort to get the job done right. So when your employees need time off to serve, remember, it's not just good for our country, it's good for your business.
Glad you could all make it.
Hi, this is Sam Rosenfarb. We're talking with Stephen Nee and Martin Gilbert of Stryker, Tams, and Dill of Newark on issues relating to business divorce. Right before the break, you were describing a circumstance. Tell us where we were, Martin.
We were talking about how husbands and wives can find themselves on a business dispute and as well as a personal dispute. A long time.
Because sometimes there are husbands and wives in business together. Right?
And with third parties. Everyone's got a few war stories, but one of mine starts with a man and his partner forming a business and giving some stock to one of their wives, but not the other. He marched into his office one day, found his, he thought, partner in there with his, he thought, wife, who informed him that they just had a board of directors meeting and he was out.
I mean, his partner and his wife banded together against him.
In all senses of the word.
Literally and figuratively, and in the business sense as well.
That's a double divorce.
A double divorce. Yeah, that happens, I guess. You know, I've never been involved in a double divorce. Some of my clients, husbands and wives who have gotten divorced from each other and have had a tough time splitting up the business. One wants to keep it. Sometimes they both want to keep it. And then it becomes a matter of replacing it with other assets.
Another situation, which is also not uncommon, Sam, is where you have a father and son or a father and daughter, and they get into a fight, or the child and the mother get into a fight, and the father eventually takes the mother's side and fires the child. And the child may have some stock in the company. So those problems also arise.
Or in-laws.
Or in-laws.
Right, sons-in-laws, daughters-in-laws.
And while, you know, it would be in everybody's interest to try and work it out amicably, this is just as bad as a divorce. The emotions are high, and unfortunately, that just doesn't happen, and it winds up costing the families a lot of money in fees and also a lot of heartache.
What are some of your most interesting cases? You know, I know you've been involved in a matter that's been going on for 20 years or so. Is that the longest case?
Well, I think it's one of the oldest cases in the state of New Jersey, and while that was not a business divorce in the sense of having a corporation, it was a business divorce in the sense of having a group of related families involved in a common enterprise where when the eldest generation was alive, it worked perfectly. But after the eldest generation passed away, widows and other people got involved, and it just broke down. And unfortunately, it's been in the courts since the, well, I guess sometime in the early 70s, and
They don't have
still is going.
the second and third generation doesn't have the same emotions as the older people do.
No, as time passes, the emotions subside.
Martin, what do you think of mediation or arbitration, some alternative dispute resolution?
They're popular. They're growing in popularity. They have to, Sam, because our courts are inundated. Everybody's in favor of it, but I think your viewers ought to know that there's pluses and minuses to it. For instance, let's talk about arbitration for a second. We learn to put them routinely in our agreements. We think they're good. The businessman takes it.
I've seen agreements where they say any dispute arising from this agreement shall be arbitrated.
But if people don't know how arbitration works, and Martin will explain that in a second, they can be in for a big shock.
For instance, people don't understand that an arbitrator, as our New Jersey Supreme Court has laid it out today, is a world unto himself. As long as he's within his authority, if he's not corrupt or acting in a incompetent way.
He becomes God.
He is. He can go and render a decision that is utterly outside the law, and the Supreme Court has said, folks, you're stuck with it. You made your decision. You constituted the arbitrator. But look, we've got alternatives now. For instance, in your contract, when you write them, you can put right in there restrictions on the arbitrator. You can say, arbitrator, you've got to act like a judge. You've got to make findings. You've got to tell us your reasoning. Better yet, you can let it go to a court to review that arbitrator if you think he's screwed up.
You can also tell the arbitrator in the agreement that he has to follow law, because one of the problems in the case that Martin is referring to is even if an arbitrator makes a mistake of law, the court can't do anything about it. And also, unless you have an agreement which requires a written decision with factual underpinnings, he doesn't have to do anything except render a decision. So you have no basis to know why the arbitrator decided what he decided.
What about mediation? Does that make sense?
I've never seen it successfully work out at the threshold of a business dispute like this.
Because mediation is gaining more and more popularity in matrimonial disputes, where a husband and wife go before one mediator, and he attempts to mold both sides. I've seen that work.
It usually comes in late in the game, unfortunately. We would all be better off if we could be reasonable at the threshold. But to borrow my story a while ago, when my friend walked into his office and found his wife and partner together, reason fled. I can imagine why. We all can. What I want to emphasize about people choosing arbitration is, if you do it, understand the trade-offs. You think you're going to get a faster result, but you're losing the power of law. Right now, we've got strong statutes to help minority shareholders. We can do this stuff if you've been caught in a squeeze.
Do you think arbitration helps the majority shareholder?
I do. I very much think it does. The arbitrator is much more constrained to look at the contract literally. A judge, a chancery judge, is much more freewheeling. He's going to do equity whether that contract constrains him precisely or not. There's a third alternative, though.
How about as an employee? An employee who's not a shareholder, who's being mistreated.
Well,
does he have the option?
Not really, because the statute provides for oppression to a shareholder in the capacity as a shareholder or an employee or a director. So the prerequisite is that the person be a shareholder.
So a long-time employee of a corporation, if he's being oppressed, that's just the nature of being an employee.
Well, he may have remedies under employment law concepts,
but not under these statutes.
Statute.
No. He may have many remedies. He may be discriminated against. He may have an employment agreement. He can be wrongfully discharged. There's a whole separate area of law protecting our employees. Shareholders are fighting about a different piece of the pie. It's their money that they've invested, they think.
You mentioned something before, which when you mentioned about arbitration, and Martin and I alluded to it, but just so we don't give arbitration a bad name, you can, in your contract, provide how the arbitration is going to work. You can provide for discovery, which in the absence of an agreement, there's no discovery, except if the arbitrator, in his discretion, lets you have discovery. You can provide that there be a written decision based on facts. And you can provide that the arbitrator follow law. So you can, if you want to, if you're careful in your drafting,
you could mold arbitration to suit your
provide those benefits. On the other hand, there's a statute, which Martin was alluding to also,
We
which
call it
covers
ADR.
Our ADR or alternate dispute resolution procedure in New Jersey.
It's new. It hasn't had a lot of play yet, but it exists on the books. We call it alternative dispute resolution. It's been called by other phrases, by those that are less kind, as rent a judge. But in fact, that's what you do. There's a statutory body that lets a true judge appoint what the statute calls an umpire that very much functions like a private judge. And now, by law, that private judge can go ahead and do everything a real judge can do, and then you can take that and confirm it, just like an arbitration award.
So how is that different than court?
Because, it's different.
reasons.
Other than you have to pay this judge.
Well, that's a big difference. Paying him is very expensive. The guys that do this tend to be private judges. They tend to charge you a very steep rate. You're going to pay for the privilege of your private judge. Many small businesses simply can't afford that luxury. There's one other reason why you might think twice about it. Suppose you need emergent relief. He's stealing from me right now. I've got to go in there and stop it right now. By the time I get my private judge online and he issues an order and I get it enforced, it might be too late.
Can you get a sitting judge to get an order that quickly? Or quickly?
If you find somebody stealing, what you would do is make an emergent application, an order to show cause to a court to try and get some sort of relief.
And judges respond to that quickly?
They will. If they're convinced of the urgency of it, you can get a chancery judge, the one we've been talking about all evening, to respond very fast.
So before anybody, do you believe that these shareholders agreement providing some security to shareholders to maintain their employment, should that be a advice followed by all businesses, all small businesses?
I think
Sometimes
so.
people can't afford it.
Well, but there are a number of ways of protecting. For instance, if you have a situation where you have shareholders who are employees, one way that you may be able to protect them is to provide in your agreement that if that employment is terminated, that employee shareholder has a right to put the stock back to the corporation, and the corporation has to buy that shareholder out, or if the corporation doesn't have sufficient assets, the other shareholder has to buy that shareholder out.
So these are alternatives that could be provided.
Get somebody to think twice before they fire someone else because, of a reason that may not be that substantial.
Is it better to be a shareholder or a partner or a member in a limited liability company? Does that depend on the circumstance?
I think it depends on the circumstance. One thing you don't want to be from a liability standpoint is a partner because, as you know, partners have unlimited liability. In a corporation, you have limited liability provided that you have set up the corporation properly and have operated as a corporation. In a limited liability company, you also have limited liability, but while people have lately, because of the newness of limited liability companies, been very hot on them, unless you have a situation where it's an investment vehicle, such as you use a limited partnership for, or it's a situation where you can't qualify as a subchapter S corporation because of the type of shareholder, it's still probably best to be a corporation.
What kind of, do the courts deal with partnership disputes and limited liability company disputes in the same way?
They haven't had a lot of chance to do limited liability companies yet. The statute's too new. Partnership disputes run very similar to the corporate disputes we're talking about right now, with one big difference, Sam. We don't have the same statute that we've been talking about.
The suppressed minority shareholder statute.
Not there in
that doesn't
the
exist.
Chancery Court would probably have the power because it's a court of equity, but still there's no statutory norm and no statutory remedy.
Could you do it anyhow? Could you walk into the court and say, give me the same remedies? Would a chancery judge be sympathetic? Yeah, I think he would. But remember, you're treading new ground.
So what advice do you have for people starting in business together? You have the friends who've been lifelong friends. They come up with an idea. They're going to make, they're going to create software.
Right. My advice to them, Sam, is to see their lawyer, see their accountant, get a good shareholders agreement, get protections built in to try and avoid these problems and hope they never arise.
And that's akin to a prenuptial agreement.
Exactly.
Right? But as we know, prenuptial agreements don't always prevent divorce, and the shareholders agreement don't prevent disputes.
But it's better.
Martin, in your experience, they help to resolve disputes?
Immeasurably. 1 ounce, the old saw about an ounce of planning being worth a lot later really holds true. And if you're going to start a campaign, if you're going to litigate, my advice is think about it first. The time to reason is right at the threshold before you start the war, before we run up the lawyers' bills and the accountants' bills. We can do better then, before you're in it. These things tend to settle often in the beginning and the end. In between is a lot of heartache.
Is greed what prompts a great deal of these partnership, family disputes?
Sometimes greed and sometimes anger.
Greed and
Sometimes
anger.
frustration.
Frustration with working too hard.
And ego.
And ego as well. This is Sam Rosenfarb for the White Collar Crime Report. We've been talking to Stephen Nee and Martin Gilbert of Stryker, Tams & Dill. Don't let the greed get you. If you have any questions about tonight's show, write to me, Sam Rosenfarb, 75 Livingston Avenue, Roseland, New Jersey, 07068. Thank you, gentlemen. Thank you. Who would have thought that airlines, banks, casinos, and railroads would ever go bankrupt? Economic times are turbulent. Bankruptcy is an alternative for individuals and businesses. Bankruptcy permits the non-payment of debts. It wipes out creditors. Bankruptcy is a legal means of saving money, and nobody knows more about money than accountants. Hi, I'm Sam Rosenfarb. I'm a forensic accountant. It's my job to determine what really happened to all the money. You're watching the White Collar Crime Report. Tonight's topic is bankruptcy. We have two partners from New Jersey's premier bankruptcy law firm with us tonight. Ken Rosen, author of numerous articles on bankruptcy, a former assistant U.S. trustee, and John Rabinowitz, an active member of the bankruptcy bar and a former law professor. Both Ken and John are partners of Raven, Saracen, Cook, Baumgarten, Fish, and Rosen of Roseland, New Jersey. Ken and John have been involved in huge bankruptcy cases, such as the Ames Department Stores case, Bally's Casino, Nutrisystems, and others. Tell us, Ken, how'd you get interested in bankruptcy?
When I got done with law school, I decided I wanted to go to business school. The market for lawyers back then wasn't very good, so I saw an ad on the bulletin board at Columbia for something called a bankruptcy analyst or financial analyst for the United States trustee, which back in 1978-79 was just a infant program. So I got a job as a financial analyst and bankruptcy attorney.
After law school?
After law school and after business school, I went to work for the U.S. trustee as a financial analyst, and also ended up that it was a job that was sort of half business, half law. Spent about 2.5 years there.
And what was your function at the U.S.
Well,
trustee's
we would
office?
conduct what's called 341 meetings, which was meetings of creditors. We would go to court, make appropriate motions, such as to force the debtor to file a plan of reorganization, to convert the case to Chapter 7 and put the debtor out of its misery if it was losing money.
Right.
We would act in some instances as sort of a creditors committee where there was no creditors committee.
So you continued in the bankruptcy arena after doing it for 2 years?
I spent about 2 years, 2.5 years at the U.S. Trustee's office, and then I went into private practice.
And you've been there ever since. How long have you been practicing?
About 15, 16 years.
Practice makes perfect. John, how did you get involved in bankruptcy?
Well, Sam, I worked for the state of New York. I worked for an agency that guaranteed student loans. And in 1978...
You said a state agency? I thought the federal government guaranteed student loans.
Well, there are several loan programs. Essentially, the federal government provides the money to back up the guarantees, but in terms of administration, it's done on the state level. There are various state guarantee agencies. This was the New York State Higher Education Services Corporation, and they guaranteed student loans and they dispensed tuition assistance, similar to the TAG grant that they have in New Jersey. In 1978, Congress passed a statute to make student loans non-dischargeable. And because...
What does that mean? They can't be discharged in bankruptcy?
That essentially
So
means,
even if you go bankrupt, you still have to pay these student loans?
That's correct. Essentially that they survived bankruptcy. They couldn't get it through the House Judiciary Committee, so they stuck it on an education bill, and it never got into the Bankruptcy Code in 1977, I guess, when it was first enacted, and nobody knew about it. And I went around the state of New York, going into various bankruptcy courts and objecting to the discharge of student loans.
Why, because the judges were discharging these loans?
Well, there is a fact-sensitive test. They are non-dischargeable unless the failure to discharge will cause an undue hardship. So the real issue was, what was an undue hardship? There was absolutely no case law. There was no standard. And I went around.
Well, isn't it always an undue hardship to pay any debt? It is for me.
That is exactly what the debtors were saying. They were saying, I am in bankruptcy. What kind of undue hardship do I have to prove?
Of course it's undue.
But the courts have evolved a standard that say something more than the mere fact that you're in bankruptcy is necessary in order to prove an undue hardship. Permanent disability, long-term unemployment, protracted divorce, something of this nature has to be
So it really has to be a
demonstrated.
hardship other than my unwillingness to pay these debts.
Well, you say unwillingness or inability to pay the debts. That's not the only criterion. That's not.
What do you find? Is it mostly unwilling or unable to pay debts that people file bankruptcy?
Well, I think if you're unwilling, you find a way to make it sound like you're unable.
Right. Is that what happens more often than not?
I think it's pretty common.
You represent both debtors and creditors, right? People who file bankruptcy to avoid paying debts and people who are owed money from bankrupt companies who are trying to collect.
We do a lot of debtor work, which is the people that owe the money. We do quite a bit of creditors committee work. Creditors committee being typically the 7 largest unsecured creditors of the debtor that get appointed to represent the interests of all unsecured creditors in the case.
Those are the businesses that have supplied merchandise to these companies.
Exactly right. Goods or services.
Not necessarily, not the banks, because they're typically secured, right?
Banks are typically secured, but we have had many instances where the bank has an unsecured claim.
Individuals can go bankrupt too, right?
Absolutely.
Is that the proper phrase, go bankrupt, or file bankruptcy?
File bankruptcy.
File for bankruptcy protection, I've heard.
File bankruptcy is probably the term of art. There are different kinds of bankruptcy. There are essentially 3 basic chapters. Chapter 7, which is a liquidation, which is available for both businesses and individuals. Chapter 11.
That means it means disposing of all your assets, selling them, converting everything to cash.
Essentially, if you have a business, the business goes out of business. There's a trustee appointed. The trustee sells the assets off and distributes them to creditors in accordance with a priority scheme set forth in the Bankruptcy Code. The second kind is Chapter 11.
Scheme doesn't necessarily mean anything.
No, scheme, I don't mean in a pejorative sense the word scheme, but there is an order in which creditors are entitled to distribution. Secured creditors come first. Taxes, wages get a higher priority as a matter of policy, and then general unsecured creditors, the trade individuals that you were making.
And individuals can go bankrupt as well.
Individuals, that's
yeah, a
correct.
good example. Remember Peter Calico, one of the major builders in Manhattan, filed a personal bankruptcy petition.
He was one of the ones aiming to buy the Post, I remember, the Post newspaper.
That's right. I think he actually owned the Post for a while.
For a
Robert
minute.
Brennan from First Jersey Securities filed a personal
Now, that's a
Chapter 11
relatively new
petition.
bankruptcy.
That's in down in Trenton.
There's some issues in that case. Aren't there something to do with, well, he's pledged some money to some charity, and that's one of the obligations that he wants discharged in this bankruptcy?
Well, I don't know whether he wants it discharged yet. 2 of the creditors in that case are St. Benedict's Academy and Seton Hall University.
They're owed money as a result of his promise to pay them some charitable
an unfunded
contribution.
pledge. I mean, he essentially gave a gift of X dollars. Some of it had been funded and some of it was still owed.
So he said, I promise to pay you X number of millions of dollars, and I'll pay you some now and I'll pay you some later.
That's correct.
And then in between paying the later, he filed for bankruptcy protection.
That's correct. And the issue that's become a legal issue, or will be a legal issue, is whether in fact they are creditors, or whether in fact they have a claim that entitles them to be treated as a creditor, that unfunded pledge.
I know from my accounting practice that these kinds of pledges become liabilities to estates when people die, that these unfunded pledges are sometimes they're asserted by charities. Are these pledges debts for purposes of bankruptcy, or is that not decided?
Well, my understanding is that, at least in the state of New Jersey, the claims are valid obligations and that they are enforceable.
So even in bankruptcy, even for purposes of determining creditors in bankruptcy, you think they'd be enforceable?
Well, the definition of a claim, without getting too technical under the Bankruptcy Code, is very broad. Creditor is somebody who holds a claim. The real issue, in my view, is consideration. Was there consideration? If, in fact, you give money away to somebody, you don't necessarily get anything back I don't know if there's
Sure, a
enforceable
gift
consideration.
is just
Exactly.
a gift. There is no consideration.
But the courts have indicated that on theories like detrimental reliance and those kinds of things, that there is adequate consideration.
One argument that gets made is that the obligation of the donor to make the gift is in partial consideration for other donors making similar gifts.
You mean he gave money, so others will give money. They want to be
Exactly right.
put in the same limelight as he is.
Well, there's a thing called matching pledges. I'll pledge $100,000 if you can raise $50,000 from X, Y, and Z individuals, and then the school goes out and they attempt to raise that money, and the $100,000 doesn't come in. That's Ken's point about essentially a detrimental reliance kind of theory.
I see. So this could be a real debt that.
Absolutely.
And then it could be discharged in bankruptcy as well.
Well, when you say discharged, ultimately, Mr. Brennan will probably file a plan of reorganization that sets forth the
How he's going to pay his debts?
How he's going to pay his debts, what their treatment will be, whether the creditors will be paid 100 cents on the dollar or something less.
So the issue isn't ultimately whether the debt gets discharged, but St. Benedict's and Seton Hall want to make sure that they participate in any distribution under a plan.
As opposed to these funds going to the federal government
Or
as
going to
payment of some penalties.
Or to go to other, exactly, the major
Right,
creditor
that's-
is an SEC penalty.
Right? Isn't that
Or-
what prompted this this filing?
I think it's about a $75 million claim.
A $75 million claim from the SEC.
Right,
That's right.
which essentially for violation of certain securities laws and fraud and punitive damages.
So how's he benefited by filing this bankruptcy
Well,
petition?
the main benefit is the automatic stay. The automatic stay of Section 362 of the Bankruptcy Code is really nothing more than an injunction. It stops all the creditors in their tracks from levying upon or seizing Mr. Brennan's assets.
So if an individual is accused or is alleged to owe money and he's being pursued, he can file a bankruptcy petition and stop all these claims.
That's right, pursuant to the automatic stay. In this particular instance, he lost in the trial level.
How did this come about, this theory of automatic stays, of being able to withstand all of your credit, put all your creditors on hold while the bankruptcy court sifts through your assets?
It's a statutory provision.
Yeah.
As a matter of policy, the
Yeah.
theory behind it is that similarly situated creditors should be treated equally. You wanted to avoid the race to the courthouse to allow one creditor who got there faster to get a preference over other creditors. So the automatic stay stops all creditors to give the debtor a breathing spell and also to allow for equal treatment of those creditors.
There's also this concept of a fresh start, which is really unique to the United States. Bankruptcy in other countries typically means liquidation. In the United States, Chapter 11 provides for the orderly reorganization and the resuscitation of debtors.
And that's unique to the United States, this
My understanding
concept
is
of
that
reorganization?
in the United States, we are one of the few countries that believe in reorganizing debtors and that keeping the company in business is better than just liquidating them.
So then, I've heard that people say this, that one way to get rich is really to go bankrupt 3 times. You get rid of your creditors, you start all over again. Can you keep filing bankruptcy?
There are prohibitions. For individuals, you can only receive a discharge once every 6 years. So that theoretically, if you were to file on day 1, you get a discharge on that day, you'd have to wait 6 years before you could file again. But that's the only real...
You talk about repeat bankruptcies. Jamesway, a local department store chain headquartered in Secaucus, came out of Chapter 11 about 10 months ago. And I read in the New York Times recently that they are now contemplating filing another Chapter 11 very shortly, because what they had expected to occur over the last 10 months, which was stronger sales and higher profits, did not occur.
How did bankruptcy help them? Did they get out of their leases as a result of
Well, that's
this?
typically one of the main functions of a retail bankruptcy. You read recently that Petrie Retail, Petrie Stores filed a bankruptcy. Chapter 11 is an excellent avenue for them to dispose of bad leases at shopping centers where they have stores that are no longer profitable.
Not all businesses have altruistic motives in going
not at
bankrupt. We'll just take a short break, and when we come back, we'll hear some interesting schemes for filing bankruptcy. Thanks.
In a recent worldwide educational test,
The United States didn't rank first
Korea,
or second
Taiwan,
or even third.
Switzerland,
It seems while the rest of the world raised their educational standards,
Scotland, Slovenia,
we didn't.
Spain,
So we came in 14th.
the United States.
And 14th is no place for our kids to be. Call 1-800-96-PROMISE, and we'll give you lots of ways to help our kids move forward again.
Just like moons and like suns, with the certainty of tides, just like hope springing high, still I rise. Bringing the gifts that my ancestors gave, I am the hope and the dream of the slave. And so I rise, I rise, I rise.
Hi, this is Sam Rosenthal for the White Collar Crime Report. We're here with two of New Jersey's preeminent bankruptcy lawyers, Ken Rosen and John Rabinowitz of the firm of Raven, Saracen, Baumgarten, Cook, Fish, and Rosen. Did I say that right?
Pretty close.
I'm sorry. So it was Cook, Baumgarten, Fish, wasn't it? Ken, tell us what your favorite bankruptcy story is, or bankruptcy case.
I guess my first bankruptcy story is my oldest. When I was working in New York, I was conducting a creditors meeting in a bankruptcy, Chapter 11 bankruptcy of a very prominent restaurant. And one of the things we were trying to decipher was whether or not the principal of the restaurant was taking out cash unreported to the state and federal government. And we were trying to figure out the percentage of credit card receipts as opposed to cash. And the principal was telling us that they had very little cash and it was mostly all quote-unquote plastic. And as a result of my experience in that case, I always ask my clients, how their family life is and whether they're happily married. Because in this case, this fellow's spouse, from whom he was very much estranged, had kept a little black book.
Oh.
And as a result of the little black book, she was able to tell us how much chopped meat they bought, and that based upon buying 50 pounds of chopped meat each week, he should have been selling 50 hamburgers instead of the 20 that he was telling us about.
So you were able to reconstruct
as a result,
all of his income.
that case was the first case that I can recall where the state of New York prosecuted the principal of a corporation for larceny for stealing sales tax receipts. Normally, the state makes, I guess it's like a 100% penalty.
Right.
They seek to collect the taxes out of the individual. In this instance, because his wife, or former wife, had kept very accurate records, he spent some time in stripes.
He did.
He did.
For stealing some sales tax
receipts.
Watch it. John, you have any interesting cases in bankruptcy?
I don't have a particular case that I worked on that was particularly interesting, but there's a recurring theme that I've seen in a number of cases that's interesting, and that is the falsification of collateral instruments for purposes of borrowing money. There are two examples that come to mind. One of them, both are classic examples, but one of them was essentially a situation where the debtor needed money in his business, and he had a credit facility with his lender. That credit facility had a formula based on the value of the collateral base. In this instance, it was accounts receivable. And he took to dumbing up invoices and giving them to the lender and borrowing money. In fact, he had never sold the goods.
Sure, he
so
just
the collateral
created
wasn't there.
receivables and inventory, similar to the Crazy Eddie case.
Not dissimilar to the Crazy Eddie case. The other example, this is a classic one that goes back some 10 or 15 years in New York, is where the debtor was in the business of leasing equipment. It was a financing mechanism for end users. And they would go to the bank and they would pledge that lease against a loan, and they would get money for it. And they got to the point where it was sort of, they were pricing their leases so cheaply, they needed more and more money, sort of a pyramid scheme. Right. And they got to the point, a Ponzi scheme, exactly, and they got to the point where they were falsifying leases, taking them to the bank and borrowing money against them. There was a classic story that came out in the New York Times where the principals were in the office and they had a glass coffee table, and they were using the glass coffee table as a mechanism for tracing signatures for falsifying the leases.
Oh, because they had the signatures underneath?
That's right. That's
That's a
essentially right.
terrific story. I mean, they
Yeah.
put the signature, the real
That's-
signatures underneath the glass coffee table,
Right.
and then they just trace the
That's
signatures on top.
That's correct. But that is a recurring theme you see throughout the cases. There is a tendency to do that which is necessary to survive.
Well, what's to prevent somebody?
We had a case a couple of years back where the controller of a manufacturing corporation went to the local bank, said he wanted to open up a new account. The controller happened to own a restaurant, and he took a check payable to his employer and went to the bank with a deposit ticket from this new account that he opened up. And as you know, when you open up new bank accounts, they give you a blank deposit tickets and blank checks. And he took the blank deposit ticket, typed the name of his employer, although the code at the bottom had the
restaurant account.
Had the restaurant account. And he took about $1 million from his employer by having the check made payable to his employer, typical accounts receivable. He made up a deposit ticket that the teller would read as XYZ Corp in the name of
that's a
his
terrific
manufacturer, and the money ended up in the restaurant.
I've been involved in this business for 25 years. I've never heard that. He took blank deposit tickets, and he just typed the name of the company.
Although the code said the restaurant.
The code at the bottom was his restaurant account,
Right,
or his
and
personal account.
That's exactly right.
Was the bank liable in that case? For
I think the bank was held liable because the bank had an obligation to check the deposit, the payor, meaning, the bank had an obligation to verify that the check made payable to the manufacturing concern was
being
actually
deposited in the right account.
Right, and they didn't do that.
It's always good to blame banks because they have lots of money.
Well, they're the deep pocket. You've got to look at the people who can pay.
What's to prevent somebody when business is bad from distributing all of his, to paying himself a bonus from his business and depleting all the money in the business to himself?
Whenever a Chapter 11 case is filed, or for that matter, Chapter 7, any bankruptcy, one of the things that the creditors committee or the trustee is charged with is taking a look at what happened prior to the time at which the bankruptcy was commenced. In other words, taking a look and seeing where the cash went. Were there specific vendors that got paid? Did they pay their American Express bill on the eve of bankruptcy?
There's some specific preference period.
There are some avoidance provisions as well. There's a preference which allows creditors who receive transfers of property or money pre-petition within a preference period. It allows either the trustee or the debtor to recover, to undo those transfers. Another protection, Sam, apropos of the issue you're raising, is a fraudulent conveyance. It would be a basic reaction of many people that if they owed money, they would want to avoid having assets against which those claims could be enforced.
Do anything to avoid paying.
They have a tendency to give those assets away. There is a concept known as fraudulent conveyance whereby the trustee, the creditors, can undo those transfers when they are done at a time when you're insolvent, when you get less than adequate consideration back, or they're done with an actual intent to delay, hinder, or defraud creditors.
So the law provides for
those mechanisms, right.
Ken, you were telling me before the break, during the break, about a story of a local builder who borrowed funds and constructed
We
a house.
represented the creditors committee of a very prominent local builder. And every time the builder would put up a new project, he'd get just a little bit more financing that he really needed. And he would use some of that financing to make a substantial improvement on his home.
His personal home.
On his personal home.
Not one of the homes he was selling.
No, on his personal home. By the time the case was commenced, he was living in a house of about 40,000 square feet.
Wow.
The only mistake that he made was that
And then his company filed bankruptcy?
His company filed bankruptcy, and the problem that he had was that his controller had recorded all of the improvements to his home as loans to officer. So when the principal of the company then filed his own bankruptcy, not just the corporation, he filed bankruptcy himself, we took the position that having made all those improvements to his house, which had been transferred to his wife, you should know, on the eve of bankruptcy.
Before he filed bankruptcy and before the business filed bankruptcy,
He transferred the house to his wife.
this house to his wife.
For
And then got a divorce, or?
No,
Oh,
they were happily married. He just took the position that he didn't own the house anymore, which meant that hundreds of thousands of dollars of improvements would be in her name rather than his name.
Well, I mean, she wasn't liable for any of these company
she wasn't
debts.
liable. So we took the position that the improvements made to the home owned by the wife was no different than having cash in the bank that he had squandered, and
he just distributed himself in
exactly right.
in prohibition of these statutes that
so
John
we
just
sued the
told us.
wife.
Well, in fact, it was a fraudulent conveyance, and Ken sued to undo the transfer
Sued
of the
the
house.
wife, and did
I
you?
sued the wife to undo the transfer of the house, and I sued the wife to collect the $600,000 or $700,000 of improvements that were made to her home or his home, depending upon how you looked at it. And we took the position that whether the cash was in the form of bricks and mortar or in the form of a certificate of deposit, it was there.
It's an asset of the estate.
It's an asset
Are
of the
husbands
estate.
liable for wives' debts? If a wife goes out on a shopping spree and a spending spree and takes your credit cards and shops at every store at the Short Hills Mall, is the husband liable for those debts?
Well, the answer is basically on a contractual basis, no, unless it's a joint credit card account, in which case there would be joint and several liability. If I have an account in my name and my wife goes out and is authorized to use that card, she's not going to be liable and vice versa. However, there are issues of authority. If somebody goes out and uses my credit card account without authority.
If there is a credit card account and she has one of the cards and you have a card, then you're both jointly liable?
Well, it depends on what the credit card agreement says. By and large, most credit card agreements provide for joint and several liability for all signatories on the account.
Now, you bring up, on the topic of credit cards, there's something called loading up. In the old days, we would see people on the verge of bankruptcy saying to themselves, look, if I'm going to file a Chapter 7 on Tuesday,
May as well have a good time.
I might as well have a good time and run the credit cards up to to their limits. Now that's prohibited. Now that's called loading up. And if you do that, there is a means by which your discharge in bankruptcy can be withheld.
So what they've done is essentially to say that if there is consumer credit on credit cards shortly before the bankruptcy, I think the period, Ken, is 45 days,
right.
Those obligations are non-dischargeable in bankruptcy. It's considered a form of fraud.
John, you told me about a employee who was murdered as a result of embezzling some funds. Tell us that story.
No personal experience involved in the case, but there was a famous case of a company and a principal who committed a bankruptcy fraud, ended up in jail, and there was a former bookkeeper who was a potential witness for future criminal prosecution, and purportedly this individual from jail put out a contract out on this individual's life, and she was killed in a parking garage in New York City. So it can get pretty serious.
Bankruptcy can be dangerous to your health as well. Huh?
Absolutely.
I was involved in a case of a supermarket owner who had 12 registers in the store, and they were all being reported, and creditors committee filed bankruptcy, and the creditors committee found an unreasonably low gross margin, and we uncovered that there was an extra register in the store.
Well, I think that's a classic, retail bankruptcy.
It took us forever to find that extra register.
Yeah, I mean, what you'll see is an inflation of the returns, inflation of the defective goods. You'll find a register that can be rolled back without the manager knowing about it.
Do you find people get very creative on the eve of bankruptcy?
I think the answer is they do try to get creative. By and large, there are, you think you started this show by asking who files bankruptcy. There are people who are bad people, for lack of a better term. There are people that are bad managers, and there are people that are affected by circumstances outside their control. I can't quantify what the percentages are, but those people that are bad people try to get creative. But there are, and a point that I wanted to make, a number of sanctions. There are criminal statutes, bankruptcy crimes, which make it a crime to conceal or transfer assets or to make false oaths or file false claims. There are the fraudulent conveyance statutes that we talked about. There are issues of objections to discharge and non-dischargeability.
There's also the risk that a trustee will be appointed. I mean, if a trustee gets appointed because there's fraud in the case, you find yourself not in control of your corporation anymore.
And then the trustee runs the corporation.
The trustee runs your business for you.
And with an inclination possibly to liquidate or sell or something of that nature, which may be against your interest.
Well, bankruptcy fraud is a crime, and you could go to jail for it. And don't let the greed get you. This is Sam Rosenfarb for the White Collar Crime Report. If you have any questions about tonight's show, write to me, 75 Livingston Avenue, Roseland, New Jersey, 07068. Thank you, gentlemen.